Something's wrong with this. Jefferson County Court at law number 2 is back in session. Court is in session in clause number 319900. The case is styled the state of Texas versus Brian Davis. Let the record reflect that Mr. Davis is present in court. His attorney, Mr. Ryan Matusk, is also present in court. And we also have Assistant District Attorney, Mr. Blake Ham, who's present in court. Oops. Mr. Sonny Eckert, City Second Chair, is also present. Mr. Bailiff, would you please bring in the jury? You may be seated. Let the record reflect that the jury is present in court in clause number 319900, State of Texas versus Brian Davis. Let the record also reflect that Mr. Davis is present with his attorney, and the state is present with his assistant district attorney. State, are you ready?
State's ready.
Defense, are you ready?
Ready, Your Honor.
Okay. And Mr. Latuska, defense has an announcement.
Yes, Your Honor, we wish to bring.
Okay, good job. You can come forward. You gotta get the clerk. I have the judges. Just have a seat. We need to get our clerk.
Okay.
She needs to do the judgment. Court is in session and calls number 319-900. Case is South State of Texas versus Brian Davis. Mr. Davis, is that your full name?
Yes, sir.
Mr. Davis, would you please raise your right hand? Mr. Davis, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
Mr. Davis, you may put your hand down. How are you doing, Mr. Davis?
I'm good. How about you?
I'm doing fine. Thanks for asking. Now, Mr. Davis, you're here represented by your attorney, Mr. Ryan Matuska. Mr. Matuska, how are you doing?
Good afternoon, Your Honor.
Good afternoon. And the state is represented by Assistant District Attorney, Mr. Blake Ham. Mr. Ham, how are you doing?
Doing well, thank you, Judge.
That's good. Now, Mr. Davis, I have before me a document that is titled Information. This information alleges that on or about April 15th of 2018, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of evading arrest detention. Mr. Davis, do you understand what you have been charged with? And to this charge, Mr. Davis, how do you plead? Guilty, not guilty, or no contest?
No contest.
Now, are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges? Mr. Davis, I have before me a document that is titled Misdemeanor Plea Admonishment. It is also labeled as State's Exhibit Number 1. Do you recognize this document?
Yes, sir.
On page 2 of this same document, Mr. Davis, there are a set of initials on a line that's next to a box that's checked nola contendere, which means no contest. Did you place your initials on this document?
Yes, sir.
On page 3 of this same document, Mr. Davis, there's a signature above the line that is titled Defendant. Is that your signature?
Yes, sir.
On the next document, which is titled Trial Court Certification of Defendant's Right of Appeal, there's a signature above the line that is titled Defendant. Is that your signature?
Yes, sir.
There are 2 boxes that are checked at the top of this document. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that?
Yes, sir.
The second box states that you're waiving your right to an appeal. Do you understand that?
Yes, sir.
I also have before me a document that is titled Discovery Certification. Mr. Davis, do you recognize this document?
Yes, sir.
Is this your signature above the line that's titled Defendant?
Yes, sir.
Mr. Davis, before you signed and initialed these documents that I have just mentioned to you, did your attorney, Mr. Matuska, go over these documents with you?
Yes, sir.
And did you read and understand everything that your attorney went over?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Davis, are you a citizen of the United States?
Yes, sir.
State, I have before me State's Exhibit Number 1. State, you like to offer State's 1?
Yes, Your Honor.
Any objections?
Objections, Your Honor.
No objections. State's Exhibit Number 1 will be admitted. Mr. Matuska,
Yeah, we have a no comment.
oh, yeah, and also I have before me State's Exhibit Number 2. State, you like to offer State's 2?
Yes, Your Honor.
Any objections?
No objection, Your Honor.
No objections. State's Exhibits Number 1 and 2 are admitted. Mr. Matuska, you have advised and counseled Mr. Davis. Is there any evidence that he is currently mentally incompetent to stand trial?
No, sir, Your Honor.
Mr. Davis, your attorney, Mr. Matuska, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Mr. Davis, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is that agreement?
Your Honor, the agreement is for 1 year deferred adjudicated probation, a $300 fine, and 40 hours of community service.
Mr. Davis, the state is offering that you serve 1 year deferred adjudicated probation. During this 1 year probationary period, you will be required to pay a fine of $300 plus court costs of $352, which comes to a total of $652. You will also be required to pay a probation fee of $60 each month, a urinalysis fee of $15 each month, and you'll be required to reimburse Jefferson County, the court-appointed attorney's fees of $250. You'll be required to pay in monthly installments. That is, you'll be required to pay in monthly installments, $160 each month while you are on probation. Mr. Davis, will you be able to pay the $160 each month?
Yes, sir.
You will also be required to perform 40 hours of community service, and you will be required to adhere to the other standard terms and conditions of this probation. Mr. Davis, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Mr. Davis, I'll follow the plea bargain agreement that you have entered into with the state. Now, Mr. Davis, if you successfully complete the probationary period, this case will be dismissed. It will not result in a conviction on your record, and you may qualify for a non-disclosure. You can talk to your attorney about the non-disclosure because he's quite competent in those matters. Mr. Davis, you're gonna stand on the X in front of our court clerk and follow her directions. And once you finish following her directions, you'll be free to go, and you have a blessed day. And Mr. Matuska, you'll be free to go as well once you sign the probation papers.
Fine, get your official light on, thank you. Jen, I can get you this on. Raise your right hand, please. Do you swear you have never been convicted or given deferred adjudication or regular probation for a misdemeanor or felony in this state or any other state, and that you have no pending charges against you that you are aware of?
Yes, ma'am.
Okay. Shows you how, once you leave here, you'll report straight to the probation office. And there's a map that's gonna tell you how to get there. Okay, thank you.
Okay, you have a blessed day. Okay. Ladies and gentlemen of the jury, what you just witnessed was what we call a plea bargain. The defendant has rights, he had a right to have a trial by jury. However, he decided to waive his right to have a trial by jury and to enter a plea of no contest to the charges. Now, I know some of you was wondering what no contest meant, but no contest, we tell them it means that a person is not fighting or they are not contesting the charges. And so they have a right to enter a plea of no contest. And the defendant received probation, but there are two types of probation. One type of probation, we call it regular probation. The other type is called deferred adjudicated or unadjudicated probation. The difference between the two is with the regular probation, it does result in a conviction on your record. Now, however, there's something that is called judicial clemency, which means that the court, the judge, can set aside that conviction. Now, there's a couple of things that has to happen. First of all, you have to complete the probation. Your probation has to expire. You cannot have any more time left on the probation. You have to be discharged from the probation. And if those things happen, the court can allow the person to come back in to withdraw their plea. And if their plea is withdrawn, then any complaint, affidavit, or information that has been filed against them will be dismissed, and they will no longer have that conviction on their record. However, if they get a subsequent conviction, if they get another conviction later on, then this case can be resurrected, revived, or brought back up, and it could be used against them. If they try to get a license with CPS, they could deny giving a license. If they have a license, they can revoke or suspend that license. Now, with the deferred adjudication, the type of probation that he just received, it does not result in a conviction on their record. And if he successfully completes the probation, he won't have a conviction on his record, and the case will be dismissed, and he can get it expunged. Well, he can get what is called a non-disclosure. And what a non-disclosure is, it cannot be disclosed to the general public that he was on deferred adjudication for that charge. Now, there are some exceptions to that rule where certain governmental agencies can have access. But for the most part, normally the general public will not be privy to the fact that that person was on deferred adjudicated probation. However, if he violates the deferred adjudicated probation, he can, a motion to revoke his probation can be filed. And if that motion is filed, he'll have a hearing before the court. And if the court finds that he has violated his probation can be revoked. And if his probation is revoked, he can get a conviction. If he get a conviction, the case is not going to be dismissed, and he's not going to get a non-disclosure. So that's what you just witnessed. But on behalf of the citizens of Jefferson County and the staff here and the Jefferson County District Attorney's Office, staff here, County Court Allotment 2, as well as the defense, we'd like to thank you for taking time out from your busy schedules to be here these past couple of days. A lot of times people think, oh, you probably was thinking, oh, we just came here, the guy, I was ready for trial, the guy pled, I just wasted a whole day. No, you did not waste the whole day. And the reason why I say that is because of this. A lot of times individuals say they want a trial. And sometimes they believe they want a trial because they believe one or two things is gonna happen. Sometimes they believe the jury is not gonna show up, or maybe a witness will not show up. And then on days when jury shows up and witnesses show up, sometimes they have a change of heart and say, you know what, that offer that the state made me a few months ago, it looks pretty good right now. And so the point that I'm trying to make is a lot of cases that are on our docket, the only way we can get those cases to move is to have a jury trial. Now, I know over the past about 2 years, we've been having the pandemic, and so we backed up. And so, but now, once we start moving cases, a lot of those cases that's on our docket for trials, they're gonna start moving, and they move because of people like you, okay? So I'd like to thank you for taking time out from your schedule. Now, I tell people this all the time, if anytime you're in the area, feel free to come and have a seat in this court. I know when you came to the courthouse, you know you had jury duty, you said, oh, this is Judge Holmes' court, I'm in the right place. No, it's not my court, it's your court. I'm only a public servant. So anytime you're in the area, please feel free to come and have a seat in county court at law number 2 to see what's going on in your courtroom. Now, we have some good coffee that's usually made by our bailiff. That area you'll be sitting in is called the Peanut Gallery. And I said it earlier, it doesn't mean you can bring peanuts up in here and eat. This is not the Texas Roadhouse. But you can come and have a seat in your courtroom and see what's going on in Jefferson County. So again, on behalf of the staff here at County Court at Law number 2, the Jefferson County District Attorney's Office, the defense, and the citizens of Jefferson County, we'd like to thank you for taking time out for your busy schedules to be here. This will conclude your jury service. The bailiff will tell you what to do with the badges. And if you want to stand around and talk to either the prosecution or the defense, you can do that. You don't have to, but you can if you desire to do that. But again, and I often say, before COVID, I will give you a handshake, but today I'll give everyone an air handshake. Okay, so you are excused.